Joining us now to talk more about the impeachment, we have UP College of Law Assistant Professor Paolo Tamase. Magandang umaga po sa inyo. I think you're on mute.
Good morning, Gretchen, and to your viewers.
Okay, I called you in to the show because I heard you have a different opinion on when this one-year bar is officially triggered on the impeachment complaint. Because the others would say that once the Committee on Justice, or once the impeachment complaints have been referred to the Committee on Justice, that's when the one-year bar starts. What is your opinion on that, reading the latest Supreme Court decision?
Well, I tend to agree that if you look at the text of the Constitution, which says that no complaint for impeachment shall be initiated more than once in a year, it seems that you count the one-year bar from initiation. And that was the rule in Francisco versus House of Representatives, this 2004, so 20-year-old case. But in the Duterte versus House of Representatives decision that came out last year, it seems to suggest that the one-year bar is counted from the dismissal of the complaint. So whether there's a violation of due process that will result in an effective dismissal, or there's a dismissal after proceedings have started, that's when the one-year bar rule starts. So you now have that unusual disparity between a rule that I think the view that it starts from initiation is universal almost. It gets asked in the bar exam. But the decision last year, I think, may have changed that.
Dismissal of what complaints?
So the impeachment complaints are treated as effectively combined when they're referred to the Committee on Justice. So when the complaint is dismissed, so likely the latter the complaint that survives if one is dismissed. Basically the latter dismissal, that's when you count the one-year bar rule. If we were to follow the Supreme Court decision last year.
Kumbaga pag may pinili na sila, tapos may dinismiss na sila dahil may pinili na.
Well, yes. No? So, for example, dun sa dalawang complaint, if yung una, i-dismiss na nila yun, the one-year bar doesn't start yet because the other one is still going along, right? It's still surviving. So, when that complaint eventually gets dismissed, either on the Committee on Justice or the House floor, then that's when the one-year bar rule will start. So if you compare, for example, yung impeachment of VP Duterte, the court counted it from February 5, which is the date when the complaints were dismissed on the House floor, not when they were filed, no, or referred to the Committee on Justice, which didn't happen anyway dun sa kaso na yun.
So, pag may na-dismiss, or pag na-dismiss yung buong set of complaints?
Effectively, yes. Effectively, when the whole set is dismissed. That's what, at least, if you look at the decision of the Supreme Court, that's when the one-year bar rule will start. So within that one-year bar, no other impeachment complaint can be filed. At least from the wording of the Supreme Court, na it's counted from the dismissal after a partial action. And I know why it's surprising because it seems to have escaped the attention of many academics from last year because of the other things that they were complaining about in the decision. But one of them is actually that it changes effectively the rule in Francisco na yung one-year bar is counted from the initiation. It's now effectively counted from the dismissal.
Okay. Is this the correct provision? I'm going to read something that I got from Duterte versus House, GR 278353, that the one-year bar should be reckoned from the initiation of the impeachment complaint if unacted upon, or when it is dismissed if it has been partially acted upon. The one-year bar may also start to commence upon the violation of the fundamental rights of the respondent, which ousts the House or the Senate of jurisdiction.
Yes,
is
that's
that
the part.
ruling that you're referring to?
Yes,
medyo
that's the
malabo, no?
section.
I mean, confusing yung provision na yan. What would be the rationale kaya for the Supreme Court to change the definition of when a complaint is deemed initiated? Why upon dismissal? Help us understand that.
So the court actually tries to explain it. Now, the way that it explains it is the purpose of the 1 year bar rule is to prevent the harassment of an official multiple times with complaints for impeachment. So my understanding from the decision is if you count the 1 year bar rule from initiation, and impeachments have traditionally taken around 3 or 4 months in the House, if you're following the process that the current two impeachment complaints are in now, then effectively the free pass that the official will only get is around 8 months before another complaint can be filed. So if they're going to uphold the spirit of that 1 year bar rule, ensure that the official isn't effectively kneecapped, by repeated impeachment complaints, that they would count it from the time that the last one is effectively terminated. That's at least how I understand the decision.
Okay, specific to what's happening now, paano kung may lumusot and it goes to the impeachment court in the Senate? When will that ruling apply to the president's case? Yung kung ano may na-dismiss ngayon, out of the two, na-dismiss yung isa nakalusot dumating sa trial, when would they determine the initiation and the 1 year bar ruling?
So the initiation is already done, right? It's already initiated effectively when the House referred the two complaints to the Committee on Justice. But when the 1 year bar rule starts to run, in your scenario, Gretchen, right? In your scenario, it will start when the complaint is dismissed pag lumusot siya sa Senate, in the Senate, right? The president is effectively acquitted. Now, there are two problems with this. The first is it seems to deviate from the text of the Constitution insofar as the prohibition is counted from the initiation, not from the fact that it is dismissed. Right? The text is quite clear. And that's where the difficulty comes from. The second is that, so that's just my respectful academic view. The second is that this is, I think, an offshoot of the problem of the decision where the court's ruling is much wider than the issues that were brought by the parties before it. So I think it could have resolved the Duterte versus House of Representatives case simply by saying that the case was, or the cases were brought without due process, and therefore the impeachment complaints filed in the House of Representatives last year were invalid. Now we'll take that as a given. But it didn't have to rule on the 1 year bar because it wasn't one of the issues, I think, that were relevant to the resolution of the case. So now you have a ruling that is untethered from the facts before the court. And therefore, hence all of this confusion. Now, I will quickly say that based on the statements, I think, in the media of the House, their understanding is that no further complaints can be filed from the initiation. But until when, is the big question.
Okay. Kasi, so iba yung when a complaint is deemed initiated and iba yung start ng 1 year bar of the next impeachment complaint. So that's what we're looking at. And you're seeing a possible conflict here from what is written in the Constitution doon sa SC ruling. Ayun. Okay, yes. Malinaw yun. Let's settle that another time. Medyo mahaba yun, ano. Pero I wanted to get your thoughts on what is going to happen now at the Committee on Justice level. They will be assessing sufficiency in form and substance of the two complaints. And magpe-present ng evidence. Isn't that tantamount to already litigating the complaint at the committee level?
So you can think of it as similar to a usual congressional hearing where you have a member of Congress or members of Congress asking questions. If that hearing if it goes to that stage, after sufficiency in form, sufficiency in substance, you will have, based also on the Supreme Court's ruling, an opportunity for the respondent to present his counter evidence or to hear the allegations against him. So closer siya to a congressional hearing than it is to a trial. In a trial in court, and if viewers still remember the Corona impeachment, what usually happens is the flow of the case is brought about by the interactions between the prosecution and the defense. And then you have a neutral, quote unquote, neutral judge at the back, listening to the arguments of both sides. That's not what's going to happen. It's going to be a congressional hearing effectively where you have the members of Congress themselves actively participating. And it shows the difference between a trial, which is adversarial in our system. You have a full protection given to the respondent, in an inquisitorial system, which is followed in the House, where they effectively do fact finding and see whether a complaint is sufficient.
But is that reasonable given the role of the House here, or does that make things unreasonably difficult?
I think it's reasonable in the sense that the purpose of the proceedings before the House is not yet to determine whether the president or the impeachable officer is guilty. The purpose is whether are there enough documents, evidence, testimony to show that this person did commit an impeachable offense. And the final question of whether he really did commit that impeachable offense is brought and tried in the Senate. So it's like a preliminary investigation in a criminal case, right? You have a fiscal gathering evidence na, is this complainant just disgruntled, or are there real grounds before which you can really find an offense? That's what's going to happen in the House. And then when we get to the Senate, yeah.
And it also gives the respondent time to respond. But how does one define a meaningful chance to respond?
I think a meaningful chance to respond means that the House should give notice, and that's required in their rules, should give notice to the to the respondent, presenting the complaints that were filed and any evidence that were already attached to the complaint. That gives, under the House rules, 10 days to the respondent to file a response to the charges. Meaningful just means that but the House gives us an opportunity, an intelligent opportunity. But if the respondent ultimately refuses to answer the charge before the House, then it shouldn't stop the proceeding in its tracks. Hindi naman titigil yung proceeding dahil lang ayaw mag-cooperate ng respondent, and therefore the House will proceed. That's the only thing that's required from the House of Representatives at this point.
Correct me if I'm wrong, but this is a new process, ba? I mean, the presentation of evidence at the Committee on Justice level, and how was it done in the past, and was that not sufficient? Why did the Supreme Court have to put in these new rules?
It's actually not new. Now, this has been mostly the procedure since the time of, I think, President Estrada. So the purpose is really to allow the House to confirm the facts alleged in a complaint. The reason why it seems new to a lot of us and to a lot of our viewers today is because this wasn't the proceeding in the last impeachment. In the last impeachment of Vice President Duterte, the House took the second option to it, which is not the hearing of a complaint, but the filing of a verified resolution. So that proceeding traditionally did not include these hearing type proceedings in public. But because of the Duterte decision, that would also be required now. And therefore, the House is actually hearing a complaint in the more traditional form, and a form that is initiated by a citizen, supported by a member of the House of Representatives.
Talking about fast track, yesterday, the two complaints were fast-tracked from the Secretary General to the House Speaker's office and then to the Committee on Justice. When they had 10 session days to put it in the order of business, referring to the House Speaker, and 3 session days to be referred to the Justice Committee. Pero in one day, nagawa nila. Pag gusto talaga may paraan, ano? But this was done in light of another complaint not being able to make it to the office of the Secretary General. And that intention was already expressed last week when they went to the office of the Secretary General. Yesterday, Makabayan Bloc's or Kabataan Party list Representative Rene Co said that it could have been because they were not able to find congressman to endorse the complaint. Do you think they were not given equal opportunity to be heard and to file their complaint, given what happened yesterday? Was all of that constitutional?
Well, I think it's constitutional. The House really does have the prerogative to proceed with referring the complaint to the Committee on Justice as soon as possible. The 10 session days is a limit. It's not a minimum. You have to they have to submit it to the Committee on Justice or refer it to the Committee on Justice within that period. So it's compliant with the Constitution. But Gretchen, just quickly, this highlights a problem with the procedure that and I hate to bring it back to that, though, but that the Duterte decision last year kind of complicated. Because before, this would not be a new strategy. This has been done in previous administrations in order to prevent a strong case from proceeding. So there will be a flimsy complaint that will be filed, no, not sham, but flimsy that will be filed. That complaint will proceed to the Committee on Justice. But by the time, a 1-year bar rule na. So no one can file a stronger complaint within basically a little more than 1 year. Right? So the check on that used to be the ability of the 1/3 of the House to file their own complaint via the separate mode. So medyo unusual yung circumstances na to. And I think that's one of the things that may have not been considered by the decision. And effectively, this is also the reason why when the media was taking this on last year, many commentators were saying that impeachment is effectively dead as a process for hearing complaints about high public officers. It's now going to be a game of technicalities, and that's what you're seeing now. Potentially, what you're seeing. This is not to say that the complaints that the House referred to the Committee on Justice are weak. I encourage everyone to read them if they have a copy of the complaint. But it certainly raises, or it certainly confirms one of the fears last year, which is we've over-technicalized, impeachment to the detriment of the process.
And so do you share that opinion that impeachment as a tool for accountability is effectively dead?
I'm not, going to say that it's effectively dead, but it's certainly very different from how it used to be. That it was an opportunity for us to really see evidence, and the defense of a person who was accused of very high crimes and impeachable offenses. I'm not sure if that can still be the venue now, because it's, as you can see from what's been happening the last few days, game siya ng unahan, timing. Right? Is it within the 1-year bar rule? We're not talking about the offenses anymore.
Parang yun nga, nakikipaghabulan, nakikipagpatintero. To
Yes.
get there, to get to that office, mala Hunger Games, ano. But we are expecting another set of impeachment complaints. I don't know how many will come, but this time against the Vice President come Feb 6. Have we ever gotten to this point before where there is potential for the two highest leaders of the country to be impeached? And how do you think would a simultaneous impeachment look like?
So certainly not. No, we've never had this situation before. I don't think we've even had a situation where two impeachable officers were being heard in the House at the same time. And it has a few day-to-day implications on the House's business. The first is, while legislation will continue, obviously the political energy and attention will be spent on these proceedings. And that's not always good. It's good to talk about accountability. But if the process is making accountability more difficult to be actually realized, then we're wasting financial resources and the time of the House, hearing multiple complaints. So there's a challenge on the part of the House to ensure that the process is seen as one with integrity, and therefore, if it's really insufficient in form, insufficient in substance, it should dismiss it. If there's sufficient evidence, then the hearing should be conducted in a way that will not be allowed as a forum for grandstanding, and really a fact-finding, straight to the point hearing. Right? So that's the challenge on the House. But on the larger political scheme, it certainly creates some sort of instability. You now have your two highest officials in the country being subject to an inquiry that will potentially result in their removal from office. And you have questions that will emerge there. So first is, sino mauuna, right? Sino maunang may impeach? Or sino unang matatanggal? That has an implication on the line of succession. And while the Constitution certainly provides for rules on what will happen if both seats are vacated by the president and the vice president, I don't think that's something that we would want to have. The instability that that creates is just too much, especially given the other things that we've been worried about, flood control and economic issues.
And once those impeachment complaints are filed against the vice president, do we expect all the evidence to come out in the Committee on Justice hearing for both officials?
I think that's the design now, especially in light of the due process focus of the Supreme Court last year. The idea is you shouldn't take the officials by surprise. And I kind of support that. No? In the ideal world, if we had that House inquiry, then we should be building the case, or the House should be building the case through those hearings that it will conduct. Hindi nila hahabulin yun at the end when they're already before the Senate, if impeachment really is the decision of the House. So it's important for the public now to actually watch. Although my concern actually is, and you can see it with the flood control, no? You have a hearing type proceeding in the House, you have a hearing type proceeding in the Senate, baka mawala na naman yung attention natin. But we should probably go against those tendencies and really try to see whether there really are sufficient grounds. And if there are none, then it's also an opportunity for the respondent to show that he or she is innocent.
But this will go through the court of the House, that determination in sufficiency in form and evidence, which could also be a subjective decision, right? Kasi boboto rin sila doon sa decision na yun. Okay, in connection to that, we're going to have actually the first complainant here, Attorney Andre De Jesus, to lay it down, what pieces of evidence that he has to present to the Committee on Justice. In the meantime, maraming salamat for your time and insights today. We have UP College of Law Assistant Professor Paolo Tamase weighing in on the latest Supreme Court decision, Duterte versus House, as well as the movements in the House. Maraming salamat.
Thank you, Gretchen.